In the light of the Kent State University incident, could you tell us what, in your judgment, is the proper action and conduct for a police force or a National Guard force when ordered to clear a campus area and faced with a crowd throwing rocks?
That was an unidentified reporter at a White House press conference on May 5th, 1970, one day after the Ohio National Guard shot and killed 4 Kent State students and wounded 9 more. They were at an anti-war protest following then-President Nixon's decision to expand the Vietnam War into neighboring Cambodia. Nixon had conducted a massive bombing campaign. Among the 4 dead was 19-year-old Allison Krauss. This was President Nixon's response.
There's one thing I am personally committed to, it's this. I saw the pictures of those 4 youngsters in the Evening Star the day after that tragedy. And I vowed then that we were going to find methods that would be more effective to deal with these problems of violence, methods that would deal with those who would use force and violence and endanger others, but at the same time would not take the lives of innocent people.
That solution remains elusive some 53 years later. Likewise, there is yet to be a complete disclosure of the facts by the government in the Kent State case. Since that day in May 1970, the U.S. government has never allowed the Krauss family to know the facts or see the evidence relating to Allison's murder on the Kent State campus. The truth of Kent State remains buried. During the Obama administration, the Justice Department declined to reopen an investigation after enhanced audio recordings of the incident came to light. The agency claimed the recordings were inconclusive as to whether an order to fire was given. This week, a lawsuit was filed by an attorney for Allison's family, seeking full disclosure of the records of a number of federal agencies, including the FBI and Justice Department, about the incident, which was termed in 2013 by the UN High Commissioner on Human Rights as targeted assassinations by the U.S. government. Michael Kuzma, the attorney who filed the suit, is based in Buffalo, New York. He's used the Federal Freedom of Information Act to secure information from various agencies, such as the CIA and FBI, in a number of cases, including the case of Native American activist and political prisoner Leonard Peltier. We spoke with Michael Kuzma via Skype on Thursday. Michael, give us some of the details around this case.
Laurel Krauss approached me in 2016, and she asked me if I would submit FOIA requests. And for your listeners, FOIA stands for Freedom of Information Act. It's a federal statute that was passed in 1966 and has been amended several times since then. But in theory, any person can request records from any federal agency. You don't have to give a reason as to why you want these records. And I've used FOIA for several decades now. I've represented everyone from Leonard Peltier, Native American activist who's imprisoned in Coleman, Florida. I've also represented Leslie Pickering, who worked the press office for Earth Liberation Front. So based on that experience, Laurel, Allison Krauss's sister, asked me if I would request records under FOIA regarding her sister, her dad, Arthur, and her mother, Doris. So I submitted these requests in April of 2016. Now, under FOIA, a federal agency, in theory, is supposed to produce the sought-after records within 20 working days. Based on my experience, that rarely, if ever, happens. So what happened with respect to the 3 requests I submitted to the FBI for records regarding Allison, Doris, and Arthur Krauss, I got acknowledgement letters, and then they gave me a few pages concerning Doris Krauss. And however, they with respect to Arthur's request, they combined it with the request for records concerning Allison, and I was told they had roughly 17,000 pages. So said, okay, that's fine. You can process the records. And occasionally they pop up. They'd ask, they being the FBI, they'd say, well, what format would you like these records? And a lot of times they produce these, they will give you paper copies, believe it or not, if you want those. But oftentimes they put the records on CDs. So we were under the impression the material was being processed. And then in September of this year, the FBI said, golly, are you still interested in those records? And I wrote them back and said, look, if we don't get those records by, I think I gave them a month or so to respond. I said, if we don't have the records by October of 2023, we will be left with no other alternative but to bring suit in the U.S. District Court for the Western District of New York. And the FBI didn't even respond to that letter, so we filed suit here in Buffalo, which is part of the Western District. It's Buffalo, New York. And we brought suit on July 26, 2023 against the Department of Justice, because the FBI is a component of the DOJ, and the case law is such you're supposed to sue the agency, not the component. So a lot of times you end up getting into these side arguments with government attorneys as to whether or not you sued the proper party.
Okay.
But the lawsuit was filed on the 26th of December, which was Tuesday, and yesterday our process server served the U.S. Attorney for the Western District of New York. What will happen next is the government will have 30 days to file an answer, and then there'll be a scheduling conference with probably a magistrate judge. And what will happen, based on my experience in Leonard Peltier's case and Leslie Pickering's case, they'll start making rolling disclosures. So finally, we'll at least get the FBI to start processing the records concerning Alison Krauss and her father, Arthur Krauss.
So this is basically triggering them to actually start filling the original request. Is that what's happening in essence?
Pretty much, because I've seen this happen with other cases I've been involved in. If you just go the administrative route, if you make the request and in good faith believe the agency, whether it's the FBI or ATF or whoever, a lot of times they just sit on these things hoping that you lose interest or give up or not know what button to push next. So by bringing suit, most people don't, you kind of go to the top of the pile, but they still move at a snail's pace, unfortunately. And you would think that given the fact that many of these records are over 5 decades old, that they would produce these records with few, if any, redactions. But unfortunately, based on my experience, they'll probably redact many, many pages.
So you filed the complaint, served the complaint. The 26th, you filed it. On the 27th, there's an automatic referral to ADR, to automatic alternative dispute resolution. So I assume that they attempt for mediation. That's just standard procedure, correct? It probably won't go there.
Well, in Buffalo, the Western District of New York, they don't have mandatory ADR with FOIA cases.
Good. So that's one less step. Because for the audience's edification, of course, it sounds like, gee, why bother going through the administrative process if nothing's going to happen? Why not go right to court? But if you do that, they basically dismiss the case for failing to exhaust the administrative remedy. So it's kind of like just a wasted time game before you ever get to talk to anybody that's going to do anything.
Well, the courts are actually part of the problem. The reason the agencies are able to drag their feet and stonewall people is because the courts don't say, look, the statute's clear. You have 20 working days, except in extraordinary circumstances, and you have to produce this material. The courts have also lost sight of the fact that disclosure, not secrecy, is the dominant feature of FOIA. And so they're part of the problem if you get right down to it. And the other thing is there are the exemptions under the law. Under FOIA, material could be held under the B1 exemption, which is a national security exemption, and then there's the B7 exemption, which has several subparts. That's the law enforcement exemption. Just because material may fall under one or more exemptions doesn't mean the agency has to invoke that exemption. They could make permissive releases, but they don't. They'll withhold, even in a case like this where the records are 50 plus years old, they'll still withhold a great deal of the material.
And what are some of the things that we're looking for or hoping to find that they might have on hand, all these years?
Well, we may find out that the FBI targeted Allison and her dad under its discredited counterintelligence program. Who knows what we may actually find? We may find they were working with the CIA to target both Allison and or Arthur. So it's hard to say what we may unearth, but I think there'll be some surprise at some point during this whole process that we get some records and we just say, my God, I can't believe they did that. But having dealt with the FBI, I shouldn't say that.
Having witnessed and read about COINTELPRO, who knows what they're capable of. Well, we wish you a lot of luck with that on behalf of both your client and just sunshine laws in general. And we'll speak with you again.
Okay, thank you, Don.
For KPFK, I'm Don DeBar.